became involved with TAMC, the Texas Attorney-Mediators Coalition. I suppose it was the end of 2012, right before the 2013 legislative session, when I got a call from Mike Amos on behalf of a group of professional attorney mediators who had really started this specialty back in the early 90s regarding a proposed Texas Rule of Civil Procedure 169. This rule had been promulgated by the Supreme Court, and it was a time for comments on the rule. And it would if it had gone through the way it was proposed, it would have prohibited the use of mediation in certain cases, which make up a large volume of cases that get mediated in the Texas civil justice system. And so Mike contacted me about helping the group of professional attorney mediators try to get some changes made in the rule, which was being considered by the Supreme Court. Originally proposed, it would have prohibited judges from ordering cases to mediation in certain circumstances, which affect a large number of cases that go to mediation. So that obviously would have had a huge impact on the use of mediation. It would have a huge impact on people in the civil justice system, on the public, and it would have basically nullified several statutes which give judges the authority to use mediation as a way to get cases resolved. In addition, the Supreme Court had appointed a special task force to work on putting this rule together, and the attorney mediators were never asked, were never consulted about their views about what the rule should look like. So what we found was that we had a lot of people making decisions about the use of mediation and its efficacy in the civil justice system without ever asking the people who are the most intimately involved with conducting mediation, using it, and making it available to the bar and the bench and the public. What took place during 2013, we started with these pretty modest beginnings. Mike Amos and Elaine Block and a group, I don't want to try to name all the names because I can't remember them, but there was a core group of attorney mediators who are well known throughout the state of Texas as the leaders of this specialty in Texas. And they got very concerned about the possibility of Rule 169 going into effect without ever having had any comments or any input from the attorney mediators. So we were able to organize a really stellar group of attorney mediators that are well known by all the lawyers and all the judges in Texas. So their opinions were very important to the Supreme Court and to various legal organizations. We were able to meet with Chief Justice Hecht and the staff of the Supreme Court, including the rule's attorney, and generate a great deal of comment about the rule from attorney mediators, from people who use mediation services, that is lawyers, and some judges that commented on it. And we were able to get the views of those who use mediation in front of the court, where it hadn't been, and the court hadn't had the benefit of this input prior to the beginning of 2013. Then, and we were able to get the rule turned around or modified so that courts could still order cases to mediation. They could take advantage of using mediation in appropriate circumstances. And we also spent a lot of time meeting with various legal organizations such as the Board of Trial Advocates, the Texas Trial Lawyers Association, the Defense Council, various judges, and meeting with members of the Supreme Court in addition to Justice Hecht to explain our position and that of the Texas Attorney-Mediators Coalition. At the same time, the legislature convened in 2013, and we were able to get the concerns of the Attorney-Mediators Coalition in front of key members of the legislature who are strong lawyers and accustomed to, and some of whom were mediators themselves and use mediation services in their own practices. And we were able to get them involved in commenting on how mediation needed to be taken advantage of. We discovered there were approximately 39 bills that were introduced in the 2013 session of the legislature that affected mediation in one way or another. So the TAMC became the spokesman for the professional attorney mediators in Texas. And we testified on a number of these bills. We met with members of the legislature who were sponsoring this legislation. We testified on their bills. We assisted them and these legislators and their staffs in commenting and helping them make their legislation better. And so as a result of that, we became the recognized voice of the attorney mediators in Texas with the legislature and with the courts. So here we are in 2014, and when we get asked, when members of the legislature, judges, legal associations, chambers of commerce, trade associations, et cetera, ask about what do the mediators think, they call the Texas Attorney-Mediators Coalition. In addition to being involved in the legislature and with the courts, we've embarked on a vigorous campaign to meet with key trade and professional associations and to educate them about the values of mediation and how important it is to the public. And those groups include, and we've developed relationships with key groups such as the Texas Retailers Association, the Texas Restaurant Association, the Texas Association of Business, the Home Builders Association, and others. And so we've developed relationships with them to inform them about the importance and the uses of mediation and how it is valuable to the civil justice system. We maintain ongoing relationships with the trial lawyers, the defense bar, and other judges groups, and most recently, Chief Justice Hecht has named Justice Deborah Lehrman as the Supreme Court's liaison to the attorney mediators and to the Texas Attorney-Mediators Coalition. So we've come from the beginning of 2013 scrambling around, not knowing what might happen next, to being recognized as the voice of attorney mediators when the legislature is considering legislation, when courts are considering rules, and when trade and professional associations are considering ways that they can assist their members. In addition to these building relationships and becoming the recognized voice of attorney mediators, both when the courts are considering things and the legislature, the National Center for State Courts has embarked on a research project to study the effect of what ultimately became Rule 169 on the use of mediation in Texas, and the TAMC was asked to have a seat at the table, was asked to provide a member of the advisory committee for this academic study that's being taken on by the National Center for State Courts, which is a research organization studying trends in state civil justice all over the country. So that's just further evidence of the place that the attorney mediators have been able to claim since we started less than 2 years ago. And you know, this is indicative of conversations that we had back in the 90s about the idea that it shows that if we don't look out for ourselves, nobody's going to look out for us. Having Rule 169 promulgated by the court with a blue ribbon panel of well-known lawyers and others without ever asking the attorney mediators, yet having a rule that would have had a huge impact on the practice of mediation and the ability of the courts and the public to use mediation, just demonstrates that if we don't look out for our own interests, nobody's going to look out for our interests for us. And there could never be a more clear example of how important it is for the Texas Attorney-Mediators Coalition to exist and be active and express its views about the need and importance of mediation to policymakers as well as to the courts and to the public. So the question is, what's next? Where does TAMC go from here? It's critical that TAMC continue its advancement of the use of mediation and the education of policymakers and the bench and the public about the use and importance of mediation in Chapter 154 of the Civil Practice and Remedies Code. Is we have to have those attorney mediators in Texas who care about the use of mediation, care about its availability to the public and to the bench and to the bar, and who make a living at it, need to be the ones who promote its use and to look out for it being available to the public and to the bench and to the bar, because nobody will do it for us. We're the only ones that will do it. So that's what's next, is we have to grow the awareness of the use of mediation. There were 39 bills in the last session of the legislature that affected mediation in one way or another. And oftentimes, those bills are very well intentioned, but they are obviously written by people who don't know a lot about it. And that's what we discovered in the last session of the legislature when members of the legislature found out that there was a set of experienced experts in the Texas Attorney-Mediators Coalition. They definitely wanted us in their office helping them with their bills. They want to do the right thing, and we need to be available to help them do the right thing. Should you care about the TAMC and what it's done in the past when your cases are mostly voluntary, that is, the parties agree to go to mediation and they're for amounts that are over $100,000. The reason you should care about it is that the promulgation of Rule 169 and the possibility that it could have been put into effect without ever having talked to the professional attorney mediators should be a clarion call that we have to look out for our own interests. Because if we're not there educating the courts and the legislature and the public about mediation, nobody's going to do it. So it's indicative of what can happen. Then 39 bills in the last session of the legislature that affected mediation in one way or another is ample evidence of people being interested in using mediation, people being interested in what effect it has on the civil justice system and on the public. And if we're not available to provide expert assistance and to be sure that it furthers the availability of mediation to the courts and to the public, then there won't be anybody else to do it. Or there will be somebody else that has a different agenda instead of assisting courts and the public to take advantage of this really marvelous tool that has evolved over the last 25 years. And protecting Chapter 154 of the Civil Practice and Remedies Code is one of the key goals and key thrusts of TAMC, and that is always at the forefront of our advocacy. So being an advocate for the use of mediation and for the use of the tools given in Chapter 154 is always going to be important. So a professional attorney mediator should care about this, because what we learned is if we don't care about it, there will be consequences that will be negative. Nobody's going to come do something good for the attorney mediators merely unless we have something to do with it. You ask about why attorney mediators should care about this and care about there being a TAMC and it being available to advocate for the interests of attorney mediators. And it's important to remember that every regulated profession, every regulated industry has representation before the legislature, that is policymakers, and in our instance, before the bench, before the courts who promulgate policy through its rules and procedures. And you have physicians, you have accountants, you have dentists, and then you have trade associations such as the home builders and the retailers and the insurance agents and myriad groups of people. And they are all here in Austin protecting their interests. And if we're not protecting our interests, we're going unprotected. We're abandoning the field to those who might have different agendas where it comes to the attorney mediators and those who want to take advantage of its benefits. So we need to be in the game, and we've gotten a seat at the table and are looked to by the leaders of the legislature and the courts. You might ask, why would somebody like me, who I am a practicing lawyer and I've been trained as a mediator and at one point in my career did some mediating, but I don't do it now. My practice is to advocate for my clients before government and regulatory bodies. So I lobby for TAMC at the legislature, and I represent TAMC in its dealings with the Supreme Court and with interactions with trade and professional associations and lawyer groups. But what I've noticed as someone who's a consumer of mediation services, someone who's an interested lawyer in the efficient and effective administration of justice, is that the use and availability of Chapter 154 and of mediation to the bench and to the bar and to the public is critical. And I observed it as your representative, as your advocate, and observed the way that members of the legislature appreciate the expert advice of the leadership of the TAMC and the input that TAMC gave on important pieces of legislation and important rules of the court. I've seen it in meetings with members of the Supreme Court, meetings with the Chief Justice, meetings with leaders of the legislature, how much they appreciate the opportunity to meet with professionals and leaders of this important part of our profession. So it's maintaining that leadership and maintaining that opportunity to have a real powerful voice is a very important and critical piece of what TAMC is trying to do going forward.